Major breaking news out of the Western District of Louisiana in the Reese case, which has caused much controversy involving whether or not 18, 19, and 20-year-olds have the right to keep and bear arms. The Fifth Circuit Court of Appeals had said yes, they do. But then there was a kerfluffle over whether or not, as part of the judgment in this Reese case, does the Second Amendment Foundation, does the Firearms Policy Coalition, and other gun rights groups in that case have to turn over their membership list to the federal government? And did Pam Bondi and her Department of Justice, did they ask for that information? Well, we have major news here. It turns out that the views of Mark Smith have been proven correct yet again in this submission jointly by the parties that no, the Bondi Department of Justice does not want the membership list and never asked for them. We'll break it down when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, this is an important video. Breaking news. As I explained to you a couple days ago, there was a lot of concern that Pam Bondi and Donald Trump and the Department of Justice were going to get the membership lists from the Second Amendment Foundation and from the Firearms Policy Coalition in conjunction with a final judgment entered in the Reese case down there in the U.S. Court of Appeals for the Fifth Circuit, specifically within the Fifth Circuit in the United States District Court, the trial court for the Western District of Louisiana. And there was a lot of kerfluffle online, a lot of concern online, and in some quarters of the internet, there was anger online that Pam Bondi was creating a gun registry or gun owner registry and had asked for these membership lists, and this was crazy and never should have done, and she's anti-Second Amendment, and the Trump administration is anti-Second Amendment, and all this other hyperbole. Now, I rolled out of bed with the flu and did a 30-minute video breaking down why that is not really correct. That number one is the Department of Justice did not ask for this information, and yet got the order from the judge, even though they didn't ask for it. And they had specifically not only had they not asked for it, they specifically disclaimed any kind of a right or privilege to get this information about the membership list. And we broke this down in great detail. Well, I'm happy to report in a joint submission, a joint motion to alter or amend the judgment in this Reese case down there in Louisiana. The parties, meaning the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the federal government, the Department of Justice, Pam Bondi on the one hand, and the Second Amendment plaintiffs, including the Second Amendment Foundation and the Firearms Policy Coalition, have come together and agreed that these lists should not be required to be turned over. Now, I want to say one thing real quick. This is a motion to amend the existing final judgment, which means that before the final judgment can be amended, the court has to approve it and change the final judgment. But the fact is that all the parties in the case, including the Department of Justice, have made this request to the court jointly together. I think there's an excellent chance that the district court judge is going to agree and amend the final judgment. No guarantee he will, but he should, and I suspect he likely will. So with that said, let's look at the critical language here that dispels the notion that the DOJ asked for this information. And I talked to several members of the press or various people in the media, and I told them DOJ did not ask us for this information. They didn't want the membership list, and that would violate longstanding DOJ policy and First Amendment law to get lists turned over to the government of any membership lists as a general matter. So with that said, let's see what this joint submission, which includes the Department of Justice signing off on this language, let's check out what it says, because it's very important for you to understand this and realize it's entirely consistent with what I said a couple days ago in my video on this very topic. The parties hereby jointly move to amend this court's judgment in the following respects. To add the following underlined and bolded language in paragraph 2B to read as follows. And B, individuals and federally licensed firearms importers, manufacturers, dealers, or collectors who are members of the Firearms Policy Coalition, Second Amendment Foundation, or the Louisiana Shooting Association at the time the action was filed on November 6, 2020, and who are identified by plaintiffs pursuant to paragraph 5. And here's the key language, folks. Listen carefully. They're asking to alter the language of paragraph 5 to replace, listen carefully, shall provide, to replace shall provide with the words may provide. You see that critical change? The current final judgment requires the Second Amendment Foundation, the Louisiana Shooting Association, the Second Amendment Foundation, the three organizations. It says they shall provide membership lists under the final judgment. But the parties have now moved to amend, to change that judgment, which requires the judge to do it, right? They can't just do it on their own. The judge has to do it. But to change the language that says that the organizations shall provide or are required to provide, and they change it to may provide, which really just says it's up to the organizations. And frankly, as a practical matter, since the organizations are not going to provide these lists, they're not going to provide it. And once you just say you can provide it if you want, you may provide it, doesn't mean you have to, right? I might go to the store, doesn't mean I'm going to the store or I have to go to the store. I might buy the car, doesn't mean I have to buy the car, right? So they want to change the judgment that says the organizations, the Second Amendment organizations, shall provide these membership lists, meaning are required to provide these membership lists under the final judgment, changing the language, they want to agree to change the language, the DOJ's agreed to this, to may provide the membership list. But as a practical matter, that ain't going to happen, which is exactly what I said on X at Four Boxes Diner, and I said on the videos. Not going to happen. I didn't think it was going to happen. And I didn't think, DOJ didn't ask for this information. They just kind of got foisted upon them by the district court judge. And I don't think the district court judge was being malicious here. I think the district court judge was trying to split the baby, was trying to walk a fine line between the final judgment requested by the government and the final judgment language requested by the Second Amendment plaintiffs. And I think that the judge got a little too cute here. He injected that language, directing the plaintiffs to turn over membership lists, but he had never raised that issue with the parties. So what should have happened, by the way, and then we'll talk about the rest of the short motion, what should have occurred was when the judge decided on his own initiative to add that language that says that the plaintiffs have to turn over membership lists to the government under the final order, what he should have done, rather than just do it on his own initiative and release it as a final judgment, he should have either sent out a draft form of the judgment to the party saying, hey, here's my draft judgment. If you have any comments on it, let me know in 2 days if I'm missing anything or I've got something wrong. Or he could have had a conference call with the lawyers in the case and said, look, this is what I intend to do. Does anyone have a problem with this? And then they could have raised their objections then. But what the judge did here, which was not really according to Hoyle, he just injected it into the case. He just injected it in the judgment, not giving either side a chance to weigh in on it. And frankly, I think if I were a district court judge, you always want to give the parties an opportunity to weigh in on a change like that because you may miss something. And here's a perfect example where neither party even thought really about the mandatory disclosure of membership lists because it wasn't litigated. It wasn't really at issue. In fact, the DOJ specifically says we're not asking for it and we're not even allowed for it. And they cite Supreme Court precedent to that effect. But somehow the judge did not get that kind of implied message and did this wrongly so. So the question is, will he fix it? I suspect he will, but we will see. But let us go on to see what else was jointly submitted by the parties. And this is equally important to going from changing the final judgment to you have to turn over the membership lists to the government to you can if you want. But look, you can send anything you want to the government, right? You don't have to do it. So it's a far cry from saying I have to send a letter in or a document in to I'm forced to do it, right? Wanting, I can, is much different than I must. So here's the other critical part of this joint motion. I think you'll find this very, very telling and consistent with what I said, which is DOJ did not want this membership list. They don't want the membership list, nor should they, because it's inconsistent with Supreme Court First Amendment precedent. In paragraph 2 of the joint motion submitted by the Second Amendment plaintiffs and the federal government, they write, quote, the government, as a general policy, does not compel disclosure of the identity of members of private organizations. And the government did not seek to do so here. Hear what I just said? The government did not seek to do So here. So you see, the parties agreed, because all the parties signed on to this document. They all agreed that the government did not seek the list of members from these Second Amendment organizations, from the Firearms Policy Coalition, from the Louisiana Student Association, from the Second Amendment Foundation. They did not seek it, and they don't do it as a general matter, which is exactly what I said when this came out. And a lot of people online were screaming about Pam Bondi and Donald Trump undercutting the Second Amendment by trying to get these membership lists. And I said, nah, I don't think that's going to happen. I understand what the order says. I get it. I understand the problem here. But it was obviously, to me, such an obvious mistake by the judge that I was kind of confident that the parties and some combination of the parties and the Fifth Circuit or this judge were going to get this fixed one way or another. And technically speaking, it's not fixed yet till the judge acts. But I suspect I don't see why the judge would object to a joint motion where all the parties agree to this sort of change to the final judgment. But again, anything is possible. The only other thing I want to note here is, as I explained in my prior videos and online, there were some other, I think, sort of errors made by the Department of Justice. And let me be clear about what my view is involving the Trump administration, the Department of Justice. I think it's very important that what I articulate here should be, I think, your general approach. Overall, the Trump administration, Pam Bondi, the Department of Justice are doing a fantastic job. Overall, they're doing a great, great job. We love them. Overall. Now, with that said, folks, it is true that the Department of Justice, that Donald Trump, that Pam Bondi, that the people that work at the Department of Justice, they're not infallible. They're not infallible. And the truth is, the Four Boxes Diner, including my lovely hair that you all love, is great, I suspect. You say so. Maybe it's true. But even if that's true, the reality is I am not infallible either. So I only point this out to say it is absolutely fair game for you to identify specific mistakes or specific things you think the Department of Justice and the Trump administration is doing strategically wrong, or some position they're taking that shouldn't be taken, or some action they're taking that could be done better. That is completely fair game. And if you see a problem, you should say something about it. But when you criticize the Trump administration or any organization or anybody for that matter, you want to be very precise and very accurate. You don't want to be hyperbolic. You see what I'm saying? You don't want to exaggerate the concern or exaggerate the problem. You want to be very careful about that, because here's the thing. If you become Chicken Little and you're constantly exaggerating a problem or a perceived problem, at some point you lose credibility and people tune out your voices. They tune out your comments. So that's why on the Four Boxes Diner channel, I try to be very fair and an honest broker as best I can for everything I see, the good and the bad and the ugly. And overall, I'm very happy with the trends involving the Second Amendment. I'm generally happy with the Supreme Court. I'm very happy with the Trump administration. But again, none of these institutions, including the Four Boxes Diner, they're not infallible. You're prone to mistakes, or you might miss something. Like here's an example here where the judge entered a final judgment that clearly is not really according to Hoyle. It's not really right, okay? I don't think the judge was doing anything here kind of nefarious. I think he just didn't fully understand the ramifications and all the relevant case law associated with just injecting into a final judgment sua sponte the demand, the requirement that the Second Amendment organizations have to turn these membership list over to the government. And had someone kind of flag the issue for this judge, I feel highly confident that that final judgment would have come across, been written in a different way. So all I'm saying is, one of the reasons why I exist at the Four Boxes Diner is try to be very precise. And when there is a reason to criticize the Department of Justice or Trump administration or Pam Bondi or whatever it is, that's fine. Do it, but do it precisely and in good faith. But be very careful about exaggerating something. Because when I saw this, I was highly confident that the federal government was not looking for membership lists of the Second Amendment organizations. It just didn't fly. It didn't sound right. It sounded wrong right from the start. And I could really see how this kerfluffle occurred. And, you know, it kind of was on the judge. It's kind of the judge caused this problem. But I think it will get fixed. And at the end of the day, all you really care about is the end result. And there's going to be bumps in the road because unlike in soccer, let's say, there really are no shutouts in litigation. There are no shutouts in politics. You're going to lose a few points. The other side's going to score a few points. There's going to be some mistakes. You're going to fumble the ball. You're going to throw a couple of interceptions, right? There's just the way the world works. We don't live in a perfect world, and you're trying to govern 350 million Americans and thousands of people and thousands of lawyers doing all sorts of stuff. So nothing is going to be perfect. So with that said, though, I think this is extremely good news that the Trump administration and Pam Bondi identified this mistake by the judge, flagged the fact that they absolutely did not want the membership list. They don't want the membership list, and they've stepped up alongside and together, holding hands, if you will, the Second Amendment plaintiffs to try to fix this wrong, which frankly was generated by the judge. With that said, I should note that the other issues associated with the potential conflation of organizational standing and the CASA universal injunction issue, which I flagged before, that is all being preserved. So to the extent there are other issues that can arise on appeal, well, that is all preserved, and I presume the Second Amendment plaintiffs will have a lot to say if they appeal to the Fifth Circuit Court of Appeals on that potential improper conflation of the universal injunction standard and the associational standing doctrine, which I think the DOJ may have slipped up there. But again, that's not necessarily for today's video. We can talk about that more in a future video. Okay, folks, hope you enjoyed today's update. Make sure you follow me over there on X at 4 Boxes Diner. Make sure you subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.